Provocation is a controversial defence that is dividing common law jurisdictions. Some, such as New Zealand, have abolished it altogether. Others, including England and Wales, have reformed it. In Ireland, where it's retained, the law is confused, and it's been described as a graveyard for trial judges. In order to reduce a murder charge to manslaughter, the defence is invoked in up to 25% of all Irish murder trials. However, it doesn't afford complete exoneration. It may be invoked where an accused claims suddenly to have lost self-control in the heat of the moment. So why the controversy? Historically, a two-part objective test of provocation was applied. First, would a reasonable man have lost self-control in the same way as the accused? Second, did they act in response to the provocation? In Ireland, in People v McComb, the Court of Criminal Appeal rejected the objective test as illogical. Since then, a subjective test has been applied to determine whether the accused felt provoked into the killing, and this is quite unique to Ireland, but it's based on a fundamental flaw. The problem is that the defence is now determined by the accused's hot-tempered temperament. So this means that an even-tempered person may be held to a higher standard of conduct than their hot-tempered counterpart. This challenges one of the key tenets of criminal law, an individual's capacity to exercise self-control. One argument advanced for its abolition is that provocation reflects male rather than female behaviour, and feminist commentators contend that despite the last 50 years of social changes, especially in relation to domestic violence cases, the reasonable man is exactly that, male. The need for reform was highlighted in People v Davis in 2001, when Justice Hardiman voiced concerns over the subjective test, saying that he approached the defence with some trepidation. That said, in 2009, the Law Reform Commission recommended retaining the defence, suggesting that it would be wrong if the law failed to recognise reduced culpability in certain homicide cases. The Commission did, however, recommend remodelling the purely subjective test along objective lines. In 2015, a flurry of appellate challenges highlighted the scope for jury misdirection whenever the defence is raised. Crucially, provocation does not negate intention. So, for example, in People v Zhao, the Court of Appeal concluded that the trial judge should have directed the jury that the defence was still available to the appellant, irrespective of an intention to kill. Despite repeated judicial concerns about provocation, little has happened since the 2009 Law Reform Commission report, and trial courts continue to struggle with a purely subjective test. So the onus now rests on the Oireachtas to provide a legislative retreat from it, sooner rather than later.